All right, part 1103, subpart B, canon ethics. Introduction. Following canon with the ethics adopt the general guideline with the practice with the transportation board, practice with the before the board, include with the lawyer to thoroughly admit with the practical practice law with the others have fulfilled the requirement to set forth 1103 with the former bound with the road with the code of the ethical agreement with the following rules of the professional conduct which apply with every activity of the lawyer of the canon do not relieve the lawyer of the any of the duty of the principle of the professional conducting with which the lawyers are bound with they apply with the similarity of the before the board do negotiate with the applicant with the other app, the ethical code of the canon and organize under the headings of practitioners. Duty for the responsibility of the board practitioner, duty for the responsibility for the client of the practitioner, duty for the responsibility of the other litigants and witness for the public. The practitioner duty for the responsibility toward the public. 1103 1103 understand the ethical conduct in court of the United States to be observed. The canon further purpose of the board of the rules of practice. With the direct with all the person appearing with the proceed with the before the conform nearly with the same ethical conduct of records of the practice before the courts of the United States of the same of the taken on the basis of the specification modify the nature of practice before the board requires. 1103.12 the practitioner do with the attitude over the board. If the duty of the practitioner maintain the respectful attitude of the board for the importance for the function for the administrator for the main of the respect of the board function for the code of the practitioner should regard with themselves the officer for the court uphold the honor and dignity of the right of the duty of the practitioner submit the grievance of the member of the employee of the board the proper authorities proper ground of compliance exists and such a case for the charges should be encouraged with the part person making them should be protected and the duty of the practitioner punctual attendance for the concise with the direct with the trial with the disposition. 1103 13 attempt to exert political personal influence of the board and is prohibited. Unethical practice for the attempt to influence the judge of the board with the threat of the political personal reprisal will mark the attention of the unusual hospitality park with the petition board member, the administrative law of the other representative of the board that unwarranted by the person's relationship with the perspective of the subject of the mentioned construction with the motive that should be avoided. Private communication with the board is prohibited. The extent of the board acts with the quasi-judicial capacity of the improperty of the litigants directly through any of the counsel with the representative of the community of the privately with the board member for the administrative laws of the other representative of the board about the pending of the case if they agree with the privately with the mere merits of the over the absence of the adversaries without the notice of the practitioner all the time of the scrupulous refrain to going beyond the ex parte representation which are clearly properly in view of the administrative of the work of the board of the communication with the board and its staff. The practitioner's duty responsibility toward the client 1103 to 15 the practitioner's duty of the clients generally. The practitioner shall restrict the law of the official minister shall not be involved with corruption with the public official with the deception of the public and give the improper for the advice of the practitioner by the deserves stern condemnation of the practitioner that should observe the advice of the client to observe the statutory law with the best of the knowledge and interpreted with the competent injunction with the practitioner own with the general duty of the practitioner can door toward the client with the respect of all of the aspects of service of the client. Alright, 1103.16 adverse influence of the conflicting interest. The time of the retain of the practitioner shall discover the claim with the circumstance of the relationship of the interest with the connection in the case of the unethical practice of the reps of the conflicting interest with the example with the expression of the consent with the concern given of the full disclosure of the fact with the meaning of this section. Practitioner represent the conflicting interest in which of the half of the one of the client do the consent to that which of the duty another client require the opposed the application represent the client with the undivided fidelity with the diverse secrets of the confidence of the bids for the subsequent acts of acceptance retain the employment of the matters adversely affecting the interest of the client with the respect of the confidence of the repose. 1103 17 joint associate with the practitioner the client officer with the assistant with the additional practitioner should be not regarded with the evidence of lack of the conflict of material should be left the determination of the client with the practitioner the client of the association and colleague with the objection of the practitioner first to retain with the client with the relief of the practitioner first retain another may come into the case. The practitioner jointly association with the case that cannot be agreed with any of the matter vital with the interest of the client with the conflict with the opposition should be directly stated with the client with the final determination client decision should be accepted by unless the nature of the difference make with the unpractical with the practitioner who have the judgment with the overrule with the cooperative the effective in an event with the practitioner do with the task of the client with the relief them of the obligation if the right any of the practitioner to forgive the proper advice for the overseeking the relief again for the unlawful with negligent practice of the practitioner again for the whom should be compliant with it should be notified in such action. 1103 withdrawal of the employment. The right of the practitioner with the withdrawal of the employment that once begun with the drive only from the good call of the desire. Consider the client but not always sufficient. The call of the withdrawal of the practitioner should not be abandoned. Unfinished task with the determination of the client except for the region of the line of the client with the persistent over the practitioner remonstrate with presenting frivolous defensive for the client with the deliberately disregard of the obligation fee the expense but in these cases the practitioner may be warned with the withdrawal after doing the notice of the client with the time allowed with the employment that another practitioner and the reason for the withdrawal might include the instance with the practitioner and discover the client with the cover the client with a determined continue with the college practitioner's own inability to conduct the case effectively upon withdrawal with the case the practitioner should be refunded with any part of the retainer clearly has not been earned. Art 1103, advising upon the merit of the client. With the practitioner should have obtained with the knowledge of the client, cause of the advising them thereof, the practitioner of the candidate opinion over the merits of the first probable result of the bringing with the case of the relay of the bending with the contempt of the litigation. Practitioner should be aware of the whole of the confident assurance of the client, especially with the employment and dependent on such assurance with a fair settlement that can be reached. The client should be advised to avoid in litigation. 1103, 20, practitioner receive the relay of the practice establishing the establishing practitioner shall avoid the overestimating value of the service of the client's ability to cover cannot justify the charge of the excess of the value of the service of the client's property that may require the lesser of the charge of the no charge all of the public quoted fees that should be adhered with the actual charge of the made with the practitioner bound with the change no more than quoted rate within 30 days following the day of their quotations and left with a different period of the time that is effective with such rate with clearly specified with the quoted and left the permission charge of the higher rate with the obtained with the vice chair and over the board with the compensation commission and the rebates of the practitioner shall accept the compensation commission rebates or other advantages of the party with the seeing over the client. How the knowledge consent with the client full disclosure contingency fees of the contingency fees should only be sanctioned by law and no case for the charity case that should be fees entirely contingent upon. The division of the fees for services divided only with another member of the board of the practitioner should be based on the division of the services of the responsible the unethical practitioner retain layman solicit employment depending on the respect of the case of the reward for the share of the fee for the practice cannot be severely condemned. Suing the client for fee. The commitment of the client is concerned with the compensation entered for the interest so far with the compatible self with respect for the right to receive the responsible compensation levels of suits against client should be resorted to only prevent injustice, imposition, and fraud. The acquiring interest in litigation of the practitioner shall not purchase the otherwise pecuniary interest of the subject matter of the litigation with the practitioner and conducting expenses. A practitioner may not properly agree with the client with the practitioner shall pay with the bearer with the expense of the litigation. He may with the good faith advance expensive of the matter with the conveniency, but not do must do so with the reimbursement of the client. With the practitioner shall bill with the collector of the client with the therein thereafter retain only with the payment of the reimbursement of the expense that actually been occurred on the behalf of the client. Witness compensation with the witness is not to be made with the contingent of the successful in the case of the witness is all the dealing with the trust of the property money with the client with the other trust property coming with the possession practitioner should be reported promptly. With the client with the knowledge consistent with it should not be commingled with the practitioner and private property of the practitioner and private use. However, the practitioner may be the go with the board and client call with the practitioner said with the role of the best effort to maintain the defense of the right of the client with the disfavor of the board of the public popularity should not cover the practitioner with the reframe of the whole discharge of the duty of the client and tell the benefit of every member to have the defense of the authorized by law. The client may expect the counsel every such remedy to defense. However, the practitioner shall act within the bounds of the law. The practitioner shall not violate the law involved in any of the man fraud, shenanery, or any of the client. 1103-22 with the restraint of the client with the improperty practitioner should deceive the client with the act of the same with the restraint of the practitioner himself with the practitioner to leave reference to the client with the conduct with the tour of the board of health with the practitioner witness for the other litigation with the client with the pursuit of the improper conduct with the practitioner to terminate the relationship. Confidence of the client with the practitioner duty of the pursuit of the client with confidence outlay of the practitioner employment by the client with the duty the extent of the practitioner employee as well, but the practitioner nor his employee shall accept the employment with the involved with the disclosure of the client's confidence without knowledge and consent with the client, even within thereafter available to source of the information. Practitioner shall not be continued employment with the discover the obligation represented with the conflict of the duty before they between the former and the newer client. If the practitioner falsely accused with the client with an opportunity with the respect for the false acquisition and announced intention of the client to commit of the crime not include with the confidence of the practitioner, but the respect of the practitioner must comply, make properly with the make disclosure to prevent the act of the protect the gamma game with the threatened. The practice of the duty of the responsibility regarding with the witness and other litigation with the public. The use of adverse and witness. The practitioner shall be deferred for seeking the information from the witness connected with the reputed with the basis of the favor of the diverse party with the assertion with the truth required with the such of the person called with the witness in proceeding. Treatment of the witness litigation over the counsel of the practitioner over the truth of the diverse witness for the litigation fairness to do the consideration should never diminish for the breach of the decline of the trial of the conduct with the call of the client has no right to the demand of the practitioner representing him to be the opposing party indulging in offense of the reverse and all attack. The practitioner shall not attempt to obstruct board investigation of the corruptly to influence witness for the potential witness during the investigation and conducting case of them improper. The practitioner allude for the personal history of the personal procular idiosyncrasies practitioner for the other side of the other wife that engage their personal abuse of the other practitioner. 1103, 26 discussion pending litigation with the public area, public press. The temper of the influence action for the attitude of the member of the administrative law of the board through the public game through the color and ordered to article of the public preference should be avoided, however, it does not begin for the public interest in favor of the board for the fact of the pending litigation made known to the public through the press in favor of the unbiased manner of the disimpassioned term of the concerns of the particular case of the appear with the justifiable statement of the public through the press for the unethical to make it anonymously. 1103 27 of the candor fairness of the dealing with the other litigation. Conduct with the practice of the board of the other practical should with the character of the candor fairness of the practice should observe the scrupulous for the principle of the fair dealing with the just consideration rights of others, and if it is not with the candidate fair with the practice, you know, with the mistake, with the misquote, with the concept, with the pay, with the testimony, with the witness, language, with the argument of the opposing practice, with the language, with the fact, with the decision in the textbook, with the knowledge, invalidate the case, side with the authority of the decision that has been overruled, otherwise impaired with the president, precedent with the statute, with the repeal, with the argument, consider with the fact with which it has not been proved with the misled, with the opposing, with the by continuing the withhold with the position, opening with the argument upon with the side of the intent to reply, this honor to deal with the other candidate, with the fact with the state with the witness, with the drawing, with the affidavit, with the other document. The president of the case, practitioner is not over the evidence known by the board, but the should reject with the order of the gift. The same before the board argument with the admission with the arguments upon with the aim of the point not properly calling the determination shall not introduce the argument remark of the statement that intent with the influence bystanders. A practitioner shall rely with the judgment concerned with the man with the incident with the trial with which may with the concave the affect with the proceeding for example the practitioner shall not forfeit the material matter of the trial whether there is no affection of the bereavement of the part of the opposing practitioner and no harm of the become of the postponing of the procedure. Practitioner shall not ignore the known customs of the practice of the board, even with law permits without giving a timely notice of the opposing practitioner. And so forth, the possible in support of the argument affecting the rights of the client that should be made with the writing and however it is dishonorable to avoid perform the agreement fairly made only with the minutes not been made with writing. Negotiation of opposing part of the practitioner shall know and waive the communicate upon with any subject of the controversy of the party represented with the aim of the practitioner. Separately, express the agreement of the practitioner representing with the testimony of the party shall notify the negotiation, make the compromise of the other party shall deal only with the opposing practitioner. Practitioner shall avoid everything that may be time that mislead with the party with the representative of the practitioner shall not abide the party as of law of the practice. Public communication solicitation practitioner shall not make the public communication solicitation employment with the contained with the fault of the fraudulent misleading the separate statement of the client and the prohibition include with the limit the use of the statement contained with the material of the misrepresentation fact of the mission with the material of the fact necessary to keep the statement from being misleading. Statement is intent with the likely to increase with the unjustifiable expectation. Statement of the fee with the information with the not completely accurate. Statement with the information past perform with the prediction of the future success. Statement of the with the play outside the content of the geographical information. Statement contained with the testimony about the endorsement of the practitioner. Statement contained with the opinion quality of the practitioner for the statement with the likely act track of the client with the youth of the showmanship with the puffery with the self-laudation, including the slogans and jingle the installational language and format. A practitioner shall not solicit the petitional client with the practitioner adequate notice if it does not want to receive the communication from the practitioner, nor shall a practitioner make the solution that involves the use of the undue influence. However, the practitioner shall not solicit the potential client with apparently physical mental condition which would unlikely to be because the extra of the reasonable to consider the judgment of the selection of the practitioner. The practitioner shall not pay the otherwise the any other person with the practitioner remember they associate the same firm with the solicitor the employee with the practitioner. If the application to be made with the use of the radio, television, pre-recorded or approved with the broadcast of the pipe of the practitioner, the recording with the actual transmission must be retained with the practitioner of the period 1 year after the date of the final transmission. A paid advertisement must be identified and left with the parent with the extent of intent of the pay of the advertisement. The practitioner shall not have the competence to give any of the value of the representative the aim of the communication medium and anticipate or in return professional public publicity and news item. Acceptance employee with the practitioner may decline with the county for the give the make defense for the convention for the intent for the merely with the harass the insurer with the opposing part of the work of the person wrong with the other way of the practitioner rather they have accept the retainer for the retainer become the practitioner that you insist the judgment of the board with the merits of the claim of the practitioner acceptance for the cave equivalent of the assertion of the client's cave proper determination. No practitioner is obligated to either adversely vote after give the potential client of the practitioner have the right to decline employment. Every practitioner shall declare the employment if he will accept the case with the bring with the board with the complaint with the contest with the defendant with the response. 1103 responsibility litigation practice the responsible by the questionable transaction bring with the questionable proceeding ungurging of the question of the defense of the client instruction cannot be used to achieve the questionable practice. 1103 the discrepancy imposition deception duty for the report of the corrupt misconduct with the practitioner upon the detection of fraud deception the practice against the board of the party and the case of the party after rectify with the practitioner practice with advising the client to forego and justly earned advantage of the stuff of the review of the practitioner shall perform the injured party of the practitioner parties of the practitioner of the appropriate step with the take with the practitioner out of the favor before the proper tribunal with corrupted the dishonest conduct shall accept it without the hesitation employment again with the practitioner with the wrongful with the crime with the practitioner upon with the trial with the case with the perjury with the head and committed with the over oath of the poor with the public ring with the man with the knowledge of the prosecuting authorities. 1103 responsibility when proposing the person for the mission of the practice before the board. Practitioner shall aid with the guardian of the board again for the mission of the candidates unfit with the unqualified because of the deficient of the immoral character qualification. Practitioner shall propose that no person of mission practice before the board unless the personal knowledge after responsible injury is responsible inquiry with the sincerely believe that he is able to vouch just for the person possessed qualification prescribed in 103. Intermediaries. The petitioner shall not be controlled with the exploit of the law of the lay agency, personal with the corporate, the interview between the client with the petitioner, the responsibility of the qualification practitioner, or individual practitioner shall avoid the relationship with the direct. Performance is due to the interest of the such for the intermediate with the practitioner, the relationship with the responsibility of the client should be directed. The practitioner may accept the employment with the organization, of the association, club, of the organization authorized law, they be with the party, receive the board with the render of the service, receive the aim of the man of the organization. The interest of the employment should only be included with the rendering of the service of the member of the organization respect. Individual affairs consider them free with the pay for the performance of the duty of the board. Nothing in this canon shall be constructed in conflict with 110320D. Partnership with a professional corporation with the name and the title of the formation of the partnership, professional corporation, along with the maintenance among practitioners should be taken away with the misleading name of the representation would create the false impression of the position privilege of the member that not duly authorized the practice of the no person shall have the practitioner no duly qualified in 11.932, 11.933. With the rules, no person duly admitted with the practice shall have the only out of the way will give the impression of that it is admitted that no fault assumed with the trade name should be used as disguise of the practitioner in partnership with the professional corporation. That was part of 1103, the part 1104, following the board copy and verification service of pleadings and generally.